Thank you, Professor Zhang, for talking to us today. Thank you for joining Chat Lounge, the program. Now, first up, in the 1990s, I know that you worked as the chief negotiating representative on intellectual property rights issue between China and the United States. Could you please tell us what work that job mainly entailed?
Okay, first of all, I would like to express our warmly welcome you and your colleagues to come to Tsinghua. That's my pleasure. Particularly this year is the year of the 20th anniversary of China's accession to the WTO, and also China's re-establishment of its diplomatic relations at the United Nations. 50 years. It's really a golden year, so everybody is busy and everybody is happy. Regarding the intellectual property negotiations between China and the US and between China and the EU, which last more than 13 years for me.
13 or 30?
13, from 1986 until 1998.
Oh, okay.
So why it lasted so long? It was difficult because intellectual property is very important for every country. It's the engine for its international economic development, scientific invention, and the promotion of patent rights, trademarks, and copyrights. Those are important for American people, but it's also important for the Chinese people.
Right.
And why they started the challenge? Do you know they have a special 301 provision?
Yes, I do.
In their trade law, and this provision, the USTR is empowered to make investigation to those countries that they believe that they do not provide adequate protection of intellectual property rights of Americans. And they put in 1985 on their watch list, priority watch list, China, India, and others. So when they came to China, and since I worked at the Foreign Trade and Economic Cooperation Ministry in the legal department, and mainly I serve as a coordinator and one of the chief negotiators of intellectual property rights on behalf of China and between China and the US. It was very difficult in the beginning because China started to establish its intellectual property system much later than that of the United States.
Right.
So only after the opening policy to the outside world that China has promulgated its trademark law in 1982. And in 1984, it's the first patent law, very important. And in 1988, it's copyright law. It's quite comprehensive. So China took a lot of initiatives to promote its intellectual property system, to also encourage people, particularly those inventors, and to have more inventions and scientific evidence, scientific development is the key for our national economic development. China also joined almost all intellectual property protection conventions, such as Paris Convention,
Right.
On the patents, and the Madrid Treaty for trademarks, as well as the Berne Convention on copyrights. And the main dispute, I think, is the direction is the same, to protect intellectual property, both domestic citizens and foreigners. And we provide also national treatment under the Paris Convention. Now the question is, one is the level of protection. The scope of protection of intellectual property should fit to the national economic development. For instance, in the beginning, China patent law didn't provide patents for pharmaceuticals and chemicals because it's very sensitive. Not only China, many developed countries, they didn't provide neither because food is important for the people. And pharmaceutical, the health, is important for the people. So for public interest, they protect pharmaceuticals patents quite later, several decades later than their first patent law. But China, since they started later, much later than the United States and the European countries. But China's progress has been made tremendously, rapidly. Nobody can deny. Take an example. China joined Berne Convention only 2 years later after her first copyright law. But you look at the United States, it took them 100 years long after their first copyright law. So you can see the progress. So very rapid progress. And I would say that after TRIPS negotiations, I was very lucky. I was one of the 10 plus 10 delegates, 10 from developing countries, 10 from developed countries, as from China as an observer to join in 1991 the last round, Uruguay round TRIPS talks. So all provisions I still remember clearly. As you mentioned, the India delegates, Brazil delegates, and the European delegates, we had very close talks to exchange views on those very sensitive and important issues. Now I should say I'm very confident that China's IP law protection is already totally met the TRIPS requirement, world standard, and rapidly increased the patents applications and the patents holders. China becomes number one under the patent office PCT in terms of the number of patents.
Right. So it sounds certainly a very complicated and very comprehensive process
Yes.
on the intellectual property rights negotiations between U.S. and China. I mean, we all know that prior to a country's accession to WTO, they have to negotiate bilateral agreements with each individual members of the WTO, and negotiations with the Americans were arguably the most difficult. And you participated in that process, in that very long and arduous journey. So tell us, what was keeping you, moving? What was driving your passion and your dedication in that whole process, and among your colleagues, your Chinese colleagues?
Yeah, do you know, since 1978, I worked in the State Investment Commission and the State Import and Export Commission. The opening policy, opening up to the outside world, becomes the fundamental principle for our national economic development. To join international communities, particularly for China's trade rapid development, the WTO GATT, before WTO, GATT, and later on WTO, is one of the three pillars of international economy, together with the World Bank, IMF, and the GATT. China was 23 initial negotiators, countries, to join GATT. So I know the importance of the issue and the worldwide visions. We need to join such very important international institutions, particularly to follow the rules. The milestone provision of GATT is unconditional MFN. You know, beginning since the opening policy 1979, the bilateral trade agreement between China and the United States, although they do have MFN, most favored nation treatment to each other, however, the U.S. has also a Jackson-Vanik Amendment. You know that?
Yes.
It means they need to have annual review for China's immigration policy and democracy policy. To join the WTO, to join the GATT, is a long struggle between two systems. One is the most favored nation treatment to abolish discrimination against the Chinese exporters and importers. Secondly, internally, China has also pursued its economic reform and trading liberalization. At the beginning of the opening policy of China, China adopted a central planning committee, the planning economy. So at that time, only about 200 state trading companies, they were allowed to do international trade. So it's a gradual opening process. And once finally China totally liberalized the trading rights to individuals, to companies, all companies, they enjoy also the rights to do international trade. The third issue is also critical, is because how to present China's economic regime, trading regime. For instance, in Chinese we say 商品经济,
right.
Commodity economy. You understand that foreigners do not understand what's commodity.
What is commodity economy?
Yes, so because they can define only market economy or non-market economy,
right.
or central planning, central plan control economy. So internally a lot of debates. Fortunately, only in 1980, I think it's 86, then the central government decided to totally liberalize and to call socialist market economy. And also is embedded in China's constitution. It's persuasive because the foreigners, they believe if you bring your system into your constitution, it certainly is binding. They do have a legal force. So for those, that's why it's difficult. And the US and the EU or other members, they want to get China's market as much as possible, and also lower the tariff. Tariff reduction is one of the most difficult negotiations because the original average level of tariff is about 50% to protect our national industries. But certainly you reduce the tariff, down to 7.4%. And many domestic industries, they said we cannot survive. They said we cannot compete with the importers. So that's also, it lasted for so long. Then I think finally it's a good process. The U.S. has abolished this Jackson-Vanik amendment to took China out from the list, and no more annual review of MFN. So between importer and exporters of the two countries, they have more predictability, and the bilateral trade relationship becomes stable and also sustainable. So I think this cornerstone or milestone provision is a very, very important MFN, non-discrimination. Still for today's, the WTO reform. Everything, can have further improvement, but they cannot move away the non-discrimination MFN. Is the fundamental principle.
Right. Now let's go to one of the highlights of your career, where you served for 8 years in the World Trade Organization Appellate body, and you were also the first Chinese person to be one of those 7 people who would sit on cases that not only attract a global attention, but also would decide, the future or the direction of international trade. Tell us, what kind of job is that, and what was it like to work as one of those 7 people?
As a law professor, certainly to be a member of the appellate body is the most rewarding time of my professional life. Because according to the DSU of the WTO, our members, there are 7 permanent members of the appellate body. They should be worldwide recognized experts in law, in trade, in WTO covered agreements matters. So to be able to work with such a distinguished team, they come from different legal systems, different countries, even different continents. So it's a challenge, but it's very interesting. It's a mutually learning process, enhancing mutual understanding. Sometimes in the internal deliberation, different views, and we debate with each other very difficultly. But afterwards, we are still good friends, good colleagues, and we treat each other for lunch, for coffee, or even still today. Yeah, professionally, we respect each other. Even we have some different views for some matters, but professionally, yes, we do appreciate each other a lot. So it's a good opportunity for me. And nowadays, I have been appointed by the president of the ICSID, International Center for Investment Dispute Settlement, and the World Bank is one of the 5 arms of institutions. Now 166 countries join. So professionally, it's a challenge, but very interesting. So I enjoy it very much.
It does sound like a very interesting job and a very, very interesting career. Now, during your time, serving on the appellate body, I know not a lot of cases were brought to that body, the top body of the WTO, every year. But how many cases relating to China are usually brought up to the appellate body to decide? And what are the usual, sticking points or focal points or disputes regarding these cases related to China?
Overall, the WTO has handled about 600 cases, almost double than the GATT era. Means in GATT period of time, only 300 cases. So it means a lot of work. For the appeal rate, it's getting higher and higher. Overall, it's in the beginning about 50%, and later, before the close down of the appellate body, it reached sometimes 80% appeal rate.
Oh, that's pretty high.
Yeah, pretty high. The reason is the delegates, they represent their countries or their governments. They want to show that they are the winners, defenders of the WTO covered agreement. That's one reason they don't want to accept the failure.
They don't want to be seen as weak.
Yes. And on the other hand, I should say, because the enforcement standard compared to the exit is different. The commercial arbitration, they need to pay a fair amount of compensation, quite high. For exit cases also, because they have to pay the losses and also legitimate expectations.
Right.
It means the future expecting profits. But in the WTO, their requirement first, you just withdraw your measure inconsistent with the WTO, or amend it, or abolish it.
So the punishment is not serious.
The first step. But after the period of reasonable period of time, 1 year or 14 months, for instance, you do not still refuse to implement, then the DSP can issue order to ask the winner to impose sanctions. So that's why they said the WTO has teeth compared to other institutions. So what I mean is they want to use every step, including the appeal process, to show that they have to do everything to represent, to define the interests of their government, of their people. So that's why apparently the appeal rate is high. Now, you mentioned to everybody concerned about the appellate body, the current situation, due to some, non-political reasons, that the appellate body closed down. One member just stopped, to restrict or pause the selection process. So if they have no more enough 7 or at least 3 members to form a division to handle an appeal, so that's why the appellate body, even they have been functioning successfully for the last 25 years, but still they closed down. It's a very pity and very bad for the international rule of law. And it's also against the DSU, because the DSU, the WTO asked for prompt, positive solution of disputes. Now there are already more than 10 appeal cases still pending for the last almost 3 years. So it's not a prompt. It's too slow, the process. China is quite actively joining the multilateral dispute settlement, which is considered as the crown jewel. So it's the most successful part of the WTO 4 functions. China, in the beginning, as a defendant, more cases, up to 47 cases.
In
Now,
how many years? 47?
Altogether,
Altogether,
for the
47
20
cases.
years.
Okay.
And then they gradually, they have brought cases against other members for their measures inconsistent with the WTO covered agreement. As applicant, they have 22 cases.
Oh, okay.
As a third party, they joined 190 cases. So it means that China respects multilateral dispute settlement system. It's important. It shows the progress of the rule of law. Yeah.
Now, still regarding to China, ever since Donald Trump was, elected American president, starting from the American government and later followed by some Western governments, there are accusations around the world regarding, China's participation in the WTO, especially on the areas like state subsidiaries to state-owned companies, as well as protection of intellectual property rights and forced transfer of technology, etc. How do you view these accusations against China? How do you view, China's performance in these areas?
Personally, as a professional, independent, impartial arbitrator, I would say that many of the accusations are baseless. Because first, for the subsidization, all countries, they use the vehicles to subsidy to a particular industry, particular subsidization to a new developed industries or the remote regions, or poor people. So they are entitled to use this tool to their rights to regulate. Developed countries, they do have subsidy. They provide subsidy. You see that the large civil aircrafts, that's on the subsidy issue. Then you mentioned, they mentioned intellectual property. I do not agree, since I spent quite long, 2 decades in my professional life for intellectual property. I have been followed closely the establishment of China's IP system. I'm very confident that China's IP system is world class, and also they have met all the requirements of TRIPS agreement. They also highly appreciate by the Patent Office, PCT, by Berne Convention. So for all professionals I met, they said, objectively speaking, the speed of IP development in China much faster than both other developed countries or other neighboring countries. So China has set up a good model for intellectual property. It's for good reasons, because China take as a national economic fundamental policy to promote scientific development. So scientific invention, very important.
But you just said this is your opinion as an individual, as a law professional. What about you as a judge on the appellate body?
As a judge, I think I have to look at the facts, and I have to look at the applicable law, and then to see under the law as a benchmark, and to look at the facts. That's all judges, their job is to read the submissions carefully, to look at what are the issues, what are the matters, so dig the truth from the facts. So only based on those evidence, then I can evaluate who is right or who is wrong.
Okay. Now, as you said earlier in the very beginning of this interview, this year marks the 20 years of China's accession to the WTO. We talk a lot about how China's accession changed China, the Chinese people, the Chinese society. What about what changes has China's accession brought to the world, especially to the rules-making process of the WTO?
Well, China has done a lot. First, for instance, by reducing greatly the tariff rate, China has opened its market. It's very important because China has a huge domestic market, and China becomes number one of international trade in goods, and the number two for trade in services. So the opening up the market is all countries can benefit because on a non-discriminative basis. And China joined also multilateral trading rules, negotiations, formulations. For instance, when I was with the WTO Appellate body, I can be, I saw by myself the active participation of China to promote the trade facilitation agreement, the extension of ITA, and also proposal to negotiate international investment facilitation agreement. And recently I heard that they just signed the day before yesterday that services in domestic regulation agreement. So I think it's still a great contribution to the multilateral trading system. China also, to protect the appeal system integrity and the balance between the appellate body and the panel two-tier system. China joined the EU and Canada and other countries to negotiate and work out MPIA, the arbitration appeal system based on Article 25. It's a temporary arrangement, it's open, it's a volunteer arrangement, but this MPIA cannot replace the AB, appellate body. So still I call everybody, the Secretary General, the Director General, and the members to push the resumption of the appellate body smooth functioning as soon as possible.
Well, thank you for putting that into perspective by letting us know what China has done to help the development of world trade as well as the rules making process of the WTO. Now, one final question: the reform of the WTO has been talked a lot and debated a lot around the world and domestically in China too. But consensus are pretty rare. It's very hard to reach that. Now, in your opinion, what principles should WTO reforms adhere to, and what role should and can China play in this process?
Everybody is keen at talking about the WTO reform. Yes, they need to bring the WTO to follow, to respond, to reply to the challenges, such as new model of trade, or new technology, digital economy, and e-commerce, etc. However, I think first the political commitment is very important. It's real multilateralism. It's not, a few members to formulate their opinions to discriminate another member. It's wrong. So I think we should emphasize the importance all countries are equal, equality and mutual respect, non-integration of each other's internal affairs is international, the United Nations Charter's requirement. But it's also the WTO requirement, MFN. So I think no matter which kind of reform, no discrimination, unconditional MFN is a fundamental principle. They should not move away. And others, I think that they should work actively on the basis of mutual understanding and cooperation spirit. Negotiations is a mutual concession process. Particularly, many of them is a technical issue. For instance, appellate body. Yes, dispute settlement is a public goods. Should be, very efficient, low cost, convenient to the party, and also I summarize the public goods is convenient to the parties, is correct according to the law, and concise, not too long, and coherence, so consistent, and also they should the conclusion of fairness and justice, and the judgment can be enforced. So once I said this several C's, my colleagues at the Appellate body, the Secretary Office, they are happy. It's the direction for our reform. Yes.
What about China's role?
China's role, yes, I think it's getting important every step. And we can see that China has sent a new ambassador.
Yes.
I know him very well. Also from the legal department of the Ministry of Commerce. He's very capable. And also a team of the embassy to the WTO. They join all the commissions, TRIPS Commission, Services Commission for the ongoing talks. And they are preparing actively for the 12th MC. Even they have been postponed a little bit, but I'm sure that I'm confident there will be a very successful MC because the ministerial conference is the highest organ of power for decision making. So. And meanwhile, I think they should work out to have more play of the DG and the Secretary Office. And they can also establish a certain task force for particular issues to work separately to call experts from different representative countries or member governments to join. Then if they are ready, they can give good advice to the incoming ministerial conference, so to save time and to be more efficient. I'm pretty confident. So political will, very important, and cooperation spirit, very important. So we will have a rule-based multilateral trading system, a real multilateral trading system. 164 members work together.
Thank you, Professor, for talking to us about these very complicated issues, and we do hope that the WTO can come to a quick response about the challenges that you just mentioned, because we are in a different world now, especially as technologies are different from the day when it was established, and we are in a different situation. Thank you again for talking to us.
Okay, thank you. As I said in my farewell speech in Geneva, I said that WTO shall never die. I'm still confident that the WTO has a bright future, even for a moment that they have some difficulties, and for long run, the three pillars getting stronger and stronger.
Okay.
Thank you.
Well, let's keep the confidence up. Thank you.
Okay.